Hey, welcome to the docket presented by Defense Diaries. I'm your host, Bob Mata, and I'm excited to be here again. Had a nice little afternoon jaunt with my boy Jay on the Karen Reed case. Went over some inconsistent testimony from the partygoers over at 34 Fairview. And while that was going on, obviously, the case that never sleeps was not sleeping. Again, we also had some big breaking news on Rex Heuermann as law enforcement was back over there again today with a fresh warrant. Which, what does that mean, babe? That means that they got some new probable cause. Oh, look, it's my beautiful and brilliant co-host, Ali Mata. What's up, girl?
Hi, all.
Hey.
Don't forget to do your little summary of, well, people are loading on anyway.
Oh, well, yeah, I will. So the Rex Heuermann thing, I don't know. I told you a little, I think you may have heard, babe. They're back over there, fresh warrant, new PC, obviously. Get that new warrant. At some point during the day, the medical examiner shows up. Oof. I don't know. Hidey hole. I'm thinking it's a hidey hole. Like they found like a spot that they did because they did a very, very 2-week thorough search. Really seemed to disassemble that house piece by piece back.
Yeah, the first time.
Yeah. So I mean, clearly they got some new intel, and I know that you're probably not aware. A couple of weeks ago, I think that they must have gotten a tip because they were out doing a search, and they in a different area, in an area that you would not expect to search other than if you received a tip to get out there, and they find this lockbox. We have no idea what they found in it. I'm curious if that had any kind of connection, or if somebody just came forward, or if it came from the producers of his wife's documentary. Like maybe she had a Robert Durst, I killed them all, of course I did moment. And they're like, so listen, she just gave up some intel. Who knows? But at this point, sadly, I missed Joe Giacalone's. He was boots on the ground over there. I'm going to have to watch it replay crew. Joe had done an update at 3, and I was like engulfed in other things. But back again to the case that never sleeps, right? And if you're new to the case, if you follow our content but are not familiar with Abby and Libby's case back in 2017 in February, it was the 13th to be exact. Abby and Libby, Abigail Williams and Liberty German were out on the trails. They'd been dropped off in Delphi, Indiana. It's kind of a nature preserve. Been dropped off by her sister, and they were left to hang out, walk, hike, take photos, do snaps, all that fun stuff that young teens like to do. And when they were supposed to be picked up around 3:00 by Libby's dad, he hit Libby up, no answer, tries for a bit, decides to get out, walks the trail, goes up to the high bridge, can't find the girls. At that point they start kind of contacting everybody they know. And ultimately at around 5:30 or maybe 5:00, somewhere in between 5 and 5:30, they decide to reach out to law enforcement after they'd exhausted all of their contacts with respect to people that may know where the girls were. And at that point, they start a search. Search goes on in some capacity throughout the night. Obviously, the larger foot soldier search probably stopped around 8, 9 o'clock. And unfortunately, the next morning, the girls were discovered on adjoining land to the nature preserve owned by Ron Logan. And 5 years goes by before they finally arrest a suspect, and that is Richard Allen. He was arrested back in October of, I think it was 2022 at this point. It seems like it's been forever. And it's been an absolute, how would you describe it, Allie? How would you describe the procedural ride that this thing has been for the past year and a half at least.
Well, you added ride, so it makes me want to say roller coaster. I was going to say been a shit show, but it's been challenging because it seems as though the police have not followed up on all the leads. The police have indicated right out to the public that they believe there are other people involved and that they were still wanting tips on other possible people involved. Yet it seems to us that they have not followed up on that at all. And they've got a guy sitting in prison instead of jail which is a whole nother issue.
Yeah, for sure. And this new filing is.
And before we get into the new filing, let's just let everybody know the state filed an objection to the defense's motion to continue. So they were supposed to have hearings on May 21st to the 23rd. The defense filed their motion to disqualify the judge or recuse the judge, or sometimes they even call it a change of venue of judge or just a change of judge. All of those things meaning the same thing. And as a result of that, the judge is without jurisdiction, meaning without power to do anything other than rule on the motion as to whether or not she should continue to be the judge in this case. Other than rule on the motion. Oh, wow. You're playing me back. Is that past me?
No, I forgot to share. I forgot to share this on Twitter. It was as you can imagine, it was a quick turnaround for us.
Yeah. So the defense filed a separate motion seeking to continue the matter, just reminding the court you can't do anything else until this is done anyway. So we need to continue all the other motions and the matters that were set for the 21st, the 23rd. The state filed an objection saying they wanted it to go to hearing. The defense filed a response to that. But when all is said and done, the judge filed an order today indicating, basically saying, I have no choice but to unfortunately continue the hearings that are set for May 21st to the 23rd because I can't do anything until I rule on this motion to disqualify. So in the meantime,
you jumped it. If you would have told me, I would have pulled it up.
Oh, well, I didn't know if you planned on going over that because it's like
of course.
Defense files its second motion to dismiss. So
well, yeah, a lot of it's moot, but I was going to go over this to explain why we're not going to go over the two earlier filings by the state and the defense because they're moot. They don't matter. And also to explain how I don't have to drive to Delphi tonight. And I'm happy about it. So yeah, as Ali's was saying, this thing came down today and looks like I don't know what time it hit. I don't have a time. It was early though. You sent it to me pretty early, right, Bay?
Yeah, it was sent to us at,
and I really just wanted to kind of read it because
10:40 in the morning.
You can literally feel the venom.
I'm sorry, 12:32 Central Standard Time.
Okay, and you know what I'm saying?
Yes, I agree. Oh yeah, she's very. It's got all the tone, undertone that she wanted it to have.
Yeah, for sure. So I figured it was worth a quick read. She just she ordered up the court has reviewed the defense second verified motion to DQ judge and request for findings of fact and conclusions of law upon denial of this request if the court denies a request filed Friday, May 17th of 2024 at 3:04 p.m. I love how she notes the time. As the court is now
and let me just say, I think she notes the time because if you remember, the state, the defense filed two different motions to continue. The first motion to continue had nothing to do with the motion to disqualify having been filed, but had more to do with the fact that they had just gotten another round of discovery from the state, including a phone extraction, and they felt that that needed to be thoroughly reviewed. So we received that around 3:02 or something Central Standard Time. I don't know when it was actually filed because it didn't have a file date. It's just the judge's signature at the bottom, sort of exactly the way that this one is. So I think that might be why, or she could just be, there's been a lot of motions filed and she wants to make very clear which one she's talking about.
Yeah. Okay. As the court is now required to review and rule upon the 42-page pleading, the court is compelled to cancel the pretrial hearing previously set with counsel's agreement. The court, therefore, orders the hearing set May 21st through the 23rd, 2024, on defendant's motion to vacate safekeeping order, defendant's motion to compel, and motion for sanction, state's motion in limine, and defendant's response to state's motion in limine, state's motion for admissibility, defendant's motion to suppress second statement, defendant's motion to suppress, and state's objection to defendant's motion to suppress, canceled over the state's objection. Transport ordered, vacated. Court to notify.
I can say, because I briefly read the defense's response to the state's objection to continuing, which I didn't bother looking at because, like you just said, it's moot. But in that, the defense is like, well, the state said that we didn't clearly let the court know that the state had objected to our motion to continue. And then they cite the language, I think it was the last sentence of one of the last sentences of their motion that said, we reached out to the state on this and the state objects to this request. And other than that, it was just the state's not citing any law that changes the fact that this court has no jurisdiction until it rules on the motion to disqualify.
Okay. So, both these things, so the memo is substantially shorter. It's not as horrifying as you said. It's only 20 pages, the second motion to dismiss, not 30. So we're 10 less than we had to do the other night, which I had a very long day. Allie is gorgeous. I agree. Boop. Yeah. Mother of guinea pigs declares you gorgeous. I concur. Way outkick my coverage with her. And happy for it. Lucky man. Lucky man. I saw some comment. Oh, seeking justice. Why is Fig throwing shade at you? Don't know. Don't care.
Who's honestly. Fig?
Some dude who apparently is throwing shade at me.
I mean,
I honestly could care less. Like, believe me when I tell you, I could care less.
No, I'm sure you could care less.
Well, I'm not telling you.
Oh, sorry.
I'm telling the folks, babe. All right. So
now I'm interested in what this shade is. I'll be like, what? Who said what about my man? Where?
People that don't listen to the content and just
probably a good thing.
like to fire on me. And maybe, I don't know, maybe they don't understand, or they have no idea what I'm saying. So they assume that I'm a defense hack, that I'm a paid shill for the defense team. I wish
we're getting paid better for it then.
yeah, because that's zero money. It's
right.
I'm out money on Delphi coverage. I'll tell you that, for as much as I've spent on hotels and driving. All right. So without further ado, let us start digging in to the newest filing. It's full
of surprises. It's
got stuff.
If it's all true, it's just outrageous. But it's been shocking to me how they have such differing opinions on stuff that seems like
the state and the defense.
Yeah, but is
that shocking to you, really?
But on things like, did they give me this, and did someone say X, Y, or Z?
Yeah, I guess. I don't know. Like, I think the state's always pulling shit, and they always think we're pulling shit. I mean, it's kind of par for the course, but like, this is major shit. Like, this is like, well, let's tell the people. Let's tell the people. See what they have to say. All right. And anytime you want to jump in, Bay, you just hop right in there, okay?
All right.
So defendant's second motion to dismiss based upon newly discovered, destroyed, and/or missing exculpatory or potentially useful evidence comes down to the accused, Richard Allen, by and through counsel Andrew Baldwin, and pursuant to the 5th, 6th, and 14th Amendments to the U.S. Constitution, Article 1, Section 12 of the Indiana Constitution, and Indiana Code 3534-14A11, moves this court to dismiss charges against the accused for destroying or losing exculpatory evidence or potentially useful evidence in violation of the standards set out in Brady v. Maryland. In support of said motion, the accused states as follows. Oh, hold on. Let me do my thing here. Let me change it to scrolling. Yeah, I forget who taught me how to do that, but I'm just eternally grateful. It's so much easier than me farting around in between two pages.
I
Okay,
didn't
so
realize you didn't know how to do that.
yeah, I'm incompetent in a lot of different ways, babe. All right, so paragraph 1, that on February 7th, 2024, the accused filed his motion to dismiss for destroying exculpatory evidence and memorandum of in support of said motion. 2, in his first motion, the defense detailed how a February 17th, 2017 interview of a third-party suspect, Brad Holder, was destroyed while in possession of law enforcement, along with multiple days of other interviews. On March 18th, 2024, a hearing was held on said matter. Paragraph 4, at the March 18th, 2024 hearing, Steve Mullen, investigator for the prosecutor's office, testified that other evidence was destroyed in 2017 as well, as it was purportedly unintentionally taped over. 5, furthermore, at said March 18th, 2024 hearing, the defense tendered Mullen's updated reports that purportedly explained how the evidence was destroyed. Hold on, I want to make sure. Just check one thing. Yeah, I'm good. 6, the prosecution did not tender these reports to the defense until after the motion to dismiss was filed. Also, said reports were only turned over to the defense after the defense requested those items from the prosecution. 7, on April 2, 2024, this court issued its ruling denying the defense motion to dismiss the charges. 8, since the time of this court's denial of said motion, the defense has learned of other exculpatory and or potentially useful evidence that the prosecution has not turned over to the defense, is missing or that the state of Indiana has destroyed. Thank fucking God they continued the trial. Huh? That's what we were saying.
It's crazy. I know. I was thinking this. I'm like, all this stuff went by.
Well, I mean, it wasn't lost on us.
No.
Well, I mean, I like our content is out there. Like in terms of like I'm not, I know you hate when I pat us on the back, but I mean, we were calling it for a month and a half that they needed to continue the trial. Who gives a shit what anybody out here thinks? You got to do what's best for your client. 9, just like Allen's first motion to dismiss, the missing destroyed evidence relates to third-party suspect Brad Holder. Brad Holder's missing phone extraction data. 10, during a recent deposition of Brad Holder, the defense learned that Brad Holder is pretty sure that he turned over his phone to law enforcement on February 17, 2017. The prosecution has not turned over any data, extractions, reports, or evidence, or other evidence from Brad Holder's phone. I mean, so he's pretty sure that's not in stone, right?
I know. I didn't understand, but they do provide some more details right now that make Brad Holder's right. But Brad Holder's pretty sure turns into, well, clearly,
no spoilers. I'm reading it fresh.
Okay.
Let me like, I like to feel all like shock and awed when I read these things. I like the guttural reactions because it pisses so many people off. God, you see Marta screaming like a maniac. Oh God. All right. 12, curiously, on the same day and at the same time that Brad Holder believes that he turned his phone over to law enforcement officers, his son Logan Holder also turned over his Logan Holder's phone. 13, the prosecution has turned over the data extracted from Logan Holder's phone. Interesting. But not any data extracted from Brad Holder's phone. All right. That convinces me. I'm pretty convinced they wouldn't get the kid's phone, but maybe the kid was dating, Abby. So maybe, right? Maybe
but Brad was a suspect at the time. So
was he a suspect or had people tipped him? I think there were a bunch of tips. I don't know that he was necessarily a suspect at that point. To be fair,
Okay.
he had been tipped on. A lot of people like, hey, this Brad Holder guy, you might want to take a peek at him. So 14, while the data from Logan Holder's phone was extracted, law enforcement apparently claim that they, LE, failed to extract data from Brad Holder's phone, even though he, Brad, and his son, Logan, turned over their phones to law enforcement at the same time. Now that I buy, I mean, we know law enforcement's not coming to a child and questioning them. Well, they shouldn't be questioning them, interrogating them, or certainly asking them for property without their parents being privy to it and consenting to it. But doesn't mean it didn't happen, right? 15, Jerry Heuermann stated under oath at a recent deposition that he believes police, quote, just looked through Brad Holder's phone, but encouraged the defense to find out for sure from the FBI. Heuermann, May 3, 2024, Dep. That's such a funny. Can you imagine Heuermann in this deposition? Yeah, I'm pretty sure we just looked through it. You should check with the feds. Check with the feds.
It gets worse. Heuermann's just all over the place.
Oh my God. 16, when asked if he, Heuermann, would have extracted data from Brad Holder's phone if given the opportunity, Heuermann was non-committal. Depends on the circumstances, but I think you'd have to ask the FBI what they did. Wow. What? Fucking kidding me? It's so bizarre. It's like, how can they think as law enforcement that that's like anybody's going to think that that's normal?
I mean, it gets worse.
Whether Holder is a dude or not, like, are you going to do the investigation? Like, that's the job. Like, how do you not, like, if you've got a bunch of people tipping this guy out enough to where, like, they're, like, if we had this conversation before, I mean, to pick up a phone and to essentially, in your mind, rat somebody out, you got to have strong feelings one way or another about that person. Now, it could be something personal, like maybe Brad, like, did something to really piss this person off. They're like, you know what? I'm going to fuck with this guy. Here's what I'm going to do. I'm going to tip him out and say he's a suspect. They should peek him out. Or things that he's said or done that may relate to the kid. We don't know. The point being that law enforcement doesn't know either. And it's their job to find out.
Apparently they got a lot of tips. So it's not just like somebody
That's
trying
what
to
I'm
get their
saying.
neighbor in
Like
trouble.
they tipped out. Tons of tips. Like, day that it goes down, people are like tipping out Brad Holder. All right, 17. Finally, after being pushed by the defense, Heuermann finally conceded that he would have extracted the data from Holder's phone if given the opportunity. 18. The defense finds it highly, got two highlys there. I'm taking it that I'm gonna peek. I'm guessing Andy wrote this. Just gonna pop down here. Yep, Andy. Andy has the, he likes the flair for the dramatic, which I appreciate. I write dramatically myself, so some people hate it. I'm a fan of it. The defense finds it highly unlikely that law enforcement would take the time to collect both Brad Holder's phone and Logan Holder's phone, but then choose to only conduct an extraction of Logan Holder's phone, especially when Brad Holder was a suspect at that time. And no evidence provided to the defense suggests law enforcement considered Logan Holder a suspect. 19, on February 17, 2017, documents specifically sought by the defense, Doug Carter emails with the FBI, provide evidence that Brad Holder was a suspect within days of the murder, and certainly on February 17, 2017, when Holder interviewed at the Delphi police station and turned over his phone to law enforcement. B, see, like, I can predict. So McClelland's response is going to be everything that guy just said is bullshit. He's saying that he turned over his phone. He didn't turn over his phone. They didn't do an extraction. It's like, we know where this is going. I know what McClelland's going to say. It's like the same thing that goes on with this thing. That's why you have hearings, Judge Gull, because put everybody on the stand, get everybody under oath, let the lawyers hash it out in court on the record. Let's go. That's why you have hearings. Who cares what either side is saying until they get in there and vet it out during a hearing? That's why you have hearings. B, State Police Superintendent Doug Carter was aware that Brad Holder was a suspect. C, even the top FBI agent in Indianapolis, Jay Abbott, was aware that Brad Holder was a suspect on February 17th, 2017. D, Logan Holder was not mentioned as a suspect in these emails. 20, this begs the question, why would Holder or why would law enforcement take both Brad Holder's phone and Logan Holder's phone, but only extract the data from Logan Holder's phone when he's not the suspect, but would
not extract?
But only extract the data from the one thing that I like, Andy says the same shit over and over and over. But would only extract data from Logan Holder's phone when he was not a suspect, but would not extract any data from Brad Holder's phone when he was a suspect? ? Additionally, the defense possesses 101 phone extractions that law enforcement conducted on a variety of other phones, many of which seemingly have little or nothing to do with the murders. This begs another question. Why would law enforcement take the time to extract data from 101 phones, most of which were not owned by suspects, yet would not extract data from Brad Holder's phone when they had his phone in their hands February 17 of 2017, and he was a suspect at that time? 23, the defense believes that the information provided strong circumstantial evidence that law enforcement did extract the data from Brad Holder's phone on February 17, 2017, and has not turned it over to the defense. Logic and common sense support this belief. 25, if law enforcement failed to extract suspect Brad Holder's phone data while it was in their hands on February 17, 2017, then the only other explanation would be that law enforcement was completely and utterly inept.
He's like, you guys pick. You guys pick.
It's one of the two. It's this or it's that. It's this or it's that. All evidence of Brad Holder's second interview with law enforcement is missing. 26, additionally, Brad Holder testified in his deposition that in addition to law enforcement's February 17th interview, which was purportedly accidentally taped over, that law enforcement conducted a second interview of Brad Holder sometime later, probably within a year or two of his first interview. 27, Holder further testified at his dep that A, law enforcement conducted the second interview at the Logansport police station, B, that the interview took about an hour and a half, C, that the interview was likely videotaped in an interview room, and D, that the interview involved much questioning about P-Dub, Patrick Westfall. 28, after the deposition, the defense alerted the prosecutor's office that the defense had A, no phone dump extraction evidence from Brad Holder's phone, and B, no evidence whatsoever in the form of video, audio reports, notes, or any other type of evidence of law enforcement's second interview of Brad Holder at the Logansport police station. On May 13th of 2024, the prosecution advised the defense by email that they cannot locate an interview of Brad Holder at the Logansport PD and have no record of Brad Holder's phone being downloaded. 30, at a recent deposition with the Unified Command's Jerry Heuermann, was asked about how the defense could obtain any information about this second interview. Heuermann said, I have no idea. I don't know. Don't ask me. What? Ask the feds. Heuermann said he had no idea, but encouraged the defense to reach out to the Logansport PD. I stand corrected. So not the feds, Logansport PD, to find out. 31, the defense is not required to locate exculpatory evidence or potentially useful evidence of third-party suspects. That is the requirement of law enforcement. 32, also, at said May 2nd, 2024 dep, Brad Holder told a third different story concerning how many times he met Abigail Williams, 2 times, and that one of Brad Holder's meetings with Abby Williams took place at Patrick Westfall's house.
I mean, that's crazy.
Ooh-wee. I'm gonna try not to lose my shit on that one. Like, I don't need people clipping me. Did you see how crazy Bob went when he read that Patrick Westfall had I mean, all right. So I'm going to read it again because depositions, if you don't know, are sworn testimony. Okay. That are taken. And in this situation, it was Brad and Andy, Baldwin and Rosie were deposing Brad Holder. And Holder had a lawyer there. And I'm sure.
In theory.
No, he did. Like, I've heard enough that Brad Holder, when he showed up at court for the hearing, he had his lawyer there. He's got a lawyer. So, you know, they've got him in there, and Holder tells a third different story, which we know is true because he first said he never met, then he met her once, now he's met her twice. And one of Brad Holder's meetings with Abby Williams took place at Patrick Westfall's house. 33, when Jerry Heuermann was confronted with Brad Holder's ever-changing stories concerning how many times Brad Holder met Abby Williams, Heuermann stated, perfectly reasonable, in my opinion, that he remembered somebody insignificant. If you've only met them twice, you may not remember that. So I don't see exactly what you're asking me. 34, when Heuermann was asked if it were likely that Brad Holder would not remember meeting Abby, when Holder was asked 3 days after the murders at his February 17th, 2017 interview, but then 7 years later, he would remember meeting Abby twice, Heuermann responded, possibly, yeah.
Mandy wants Holman's voice to be grittier.
It's not grittier, though.
Oh, girthier? Or I guess
girthier?
it's probably grittier. No, yeah. It's, wait.
Girthy, definitely girthy.
Oh, okay.
Grittier. Say, yeah, possibly, yeah, maybe. That's gritty. We don't I've seen him. He's not gritty.
Okay.
35, Heuermann, girthy. Possibly, yeah. Maybe that's I don't know. Heuermann showed no curiosity nor interest whatsoever about why Holder's stories have changed. This attitude supports an argument which defense will later make in this motion that law enforcement have acted intentionally or in bad faith to conceal evidence to such a degree that they cannot even admit obvious factual inconsistencies that point the finger at third-party suspects.
She does not like when they try to rely on connect the dots to find that they are acting in bad faith.
But what are they supposed to do?
I understand. They're trying to show that they have a complete either disregard for this information or are unwilling to, that the fact that they're unwilling to acknowledge something that's right on the face of it screaming out to them shows that some sort of ill will, but you know, it's not going to go.
Yeah, I totally. But here, man, like what else are they supposed to do? Unified Command is never going to sit there and say, yeah, we fucked this up. Right. Unified Command and Carroll County has a huge amount of money sunk into the prosecution of Richard Allen. No one is backtracking on that. No one, you know? So when you have a situation like this, where this kind of stuff just keeps arising time and time again, and they're just not getting, I mean, they have to ask the questions. They have to make those assumptions. I surely would be. I'd be assuming all the same shit that they are. Like none of what they're assuming is crazy.
No, not at all.
Is completely disingenuous and full of shit. But like, honestly.
I mean, clearly Brad Holder knew the details of when he was interviewed. He said where he was interviewed. He said the length of his interview. He said questions they asked during the interview. So, you know, and the fact that the state's like, oh, we've got no record of this interview, you know, either is just absurd. What are you giggling about?
Potentially criminal.
Oh.
What's up, Sean? Yeah, he's Sean's a great guy. Dude, right? Like, oh my God. All right, let's keep plowing through. So Patrick Westfall was interviewed on August 17, 2024, and law enforcement extracted data from Westfall's phone. the phone extraction shows that Westfall's phone had no data prior to August 11th, 2023, which was the day that law enforcement contacted Westfall and asked him to come in to be interviewed 1 week later. In other words,
I wonder if law enforcement's going to find this one suspicious. I'm waiting with bated breath.
I'm
Mm.
going to guess no. In other words, it appears that Patrick Westfall either erased all of the phone data on his phone or purchased a new phone after police contacted him on or about August 11th, 2023. The only data found on Westfall's phone between August 11th, 23, or on or about when police contacted him, and August 17th of 2023, when he was interviewed, no texts, videos, photographs, emails, nor any other data existed on Westfall's phone before the day that police contacted Westfall on August 11th, 2023. Sounds perfectly, totally plausible. Plausible.
Sounds like they should have tried an iPhone download, or if he really deleted everything off of his phone or got a new device, I wonder if they tried other avenues. iCloud.
I think if he does a factory restall or factory, like he wipes it and does like the factory reboot or whatever the fuck it's called, like, does that wipe it where Cellebrite's not going to bring it on? If you actually wipe the device.
I believe so, but I'm not sure, but I think so. But he would, unless he also went to his iCloud and deleted his prior backups, the state still had the ability and should have been suspicious enough. I mean, I'm waiting to see here. Maybe they found it real suspicious, but they should have been suspicious enough to get his iCloud data to like, this guy deleted everything. There's nothing on his device since the date that we contacted and told him that we were going to,
But we run into the same issue on August 11th of 2023. They have a man in custody that they have spent a fuck ton of money prosecuting. People forget about that side of this, of the law game. People forget about how much money that is sunk into the trial and ultimately seeking a conviction of a defendant in a case like this. It is a lot of money. Like everybody on that side of it, the prosecution, law enforcement, have a vested interest in seeing this thing through until the end. I don't know that they care about the truth. I think they care about getting a conviction of the person that they said is the person who did this. I actually believe that Doug Carter and Heuermann and Liggett actually, with all of their hearts, firmly believe that Richard Allen's the guy. To the extent where they just aren't hearing anything else.
Well, but the fact of the matter still exists that the state has made abundantly clear they believe that, or at least have a strong possibility that others were involved. So there's still no reason why they should not have obtained the iCloud backup for Heuermann's device.
Because they know.
I mean, Heuermann,
they're not going to be able to.
Patrick Westfall's device.
I know what you're saying, and I think everybody else did too. The problem with that is that they know, being law enforcement, there is no connection between Richard Allen and these guys. That's the fly in the ointment, dude. Like, that is the fly in the ointment. Believe me, if there was any connection, and you know how I know that? Because I'm a genius. No, because if they had anything connecting Allen to any of these guys,
the defense would
be under arrest.
No, and the defense wouldn't be. And the defense wouldn't be putting them forth as their third-party suspect, probably.
Yeah, because they'd be under arrest. I'm just telling you, if they had a connection to any of these guys, any of them, with Richard Allen, the guy that they're convinced is Bridge Guy and who got the girls down the hill, they're convinced of it. 100% convinced of it. If they had anything connecting that guy to any of these guys, one of these guys or all of these guys would be under arrest. I guarantee it. They don't have it. And that's the fly in the ointment. because they know if they say, okay, well, it's these guys, they're essentially letting Allen walk. They can't add him to the mix because it fucks up their case to Allen, because there's no like, oh, so we're now to believe that Richard Allen is bridge guy and he walked down and he just happened to find a bunch of Odinists hanging around down on, Ron Logan's property waiting for somebody. Maybe somebody will bring a couple girls down. Like, I mean, it's,
Yeah, but if they're intentionally not looking for evidence on Holder's phone, they keep losing his,
I don't know that they're not intentionally. You know what I'm saying? Like,
okay,
I
so
am,
maybe the first one was a mistake, but where's the second interview? There's no way in hell that the police don't have that somewhere. It's not being turned over for some reason. So it doesn't speak to them actually wholeheartedly. I mean, you could say they might wholeheartedly believe, but you know what? They might not, and they might not give a shit, that they just want to close a case.
that, like, when you say words like that, it makes me throw up in my mouth a little bit. Like,
I know,
to
because
ever think that law enforcement, anyone, any cop with that much power would knowingly arrest and like actively work to convict a person that they know that didn't do it. It's the most disgusting thing
I'm sorry,
I've
I
ever
forgot.
heard.
Did you not watch the Baltimore thing?
Are you acting like I don't know that it happens all the time?
I know. And it
Yeah.
happens in Chicago, and
A
it's
lot of
documented in
people think that it
Chicago.
never happens. A lot of people think that that's just crazy talk. But
They got their heads up their asses.
well, I mean, they live in a, in a very bright and happy
Sheltered.
world,
Yeah.
with puppy dogs and ice cream cones, and cops are all good guys, and terrible shit never happens, and people aren't awful. Must be that must be like a great place to live in your brain. Sounds wonderful. 39, when Jerry Holman was confronted with the fact that Patrick Holder likely attempted to hide his phone data from the state police, Holman claimed that he found nothing unusual, stating, quote, "People erase things all the time." Are you fucking kidding me? Later, Holman stated that he found nothing suspicious about Patrick Westfall deleting or concealing his phone data before his Westfall's August 17th interview.
Nothing suspicious there.
Nothing to see here. Move along. Move along. Just
Again,
keep moving.
that's the kind of thing that takes away from them thinking they actually have, the right guy.
Yeah. 40. Again, Holman's attitude towards third-party suspect P-dubs supports the defense's position that law enforcement has intentionally destroyed evidence or acted in bad faith or have intentionally not provided missing evidence, such as Brad Holder's second interview, as well as the other items identified in this motion. 41. At his August 30th, 2023 interview, State Trooper David Vito did not even ask Brad Holder if Holder, would allow the state police to extract data from Holder's phone, even though it was clear that Holder had brought his phone with him to the interview. Therefore, it is not known whether Holder similarly hid or erased data from his phone, like it appears Westfall hid and erased data from his phone. 43. It certainly is curious as to why Vito did not request Holder's phone data when Holder brought his phone to the August 30th, 2023 interview. Like, I want to spoiler alert. Have they deposed Vito yet?
That's as far as I didn't get further.
Okay. Oh, look at us both with gut reactions. I love that. 44. It is also curious as to why Vito failed to ask Brad Holder one single question about Elvis Fields. No one is ever getting me off the Elvis Fields shit. Ever. It's like when we had Osbrick on, and he's like, he's like, the thing that I just can't get over with the whole Elvis Fields thing, and is like, you've got these interviews or confessions from this guy who's been in solitary for a year, who's clearly got some mental issues going on. He's eating his own shit. He's eating like whatever, all the horrible shit that's been going on with Allen or was going on with him at Westville. And people take those as gospel. Like without the benefit of having heard any of them. Like, I mean, we've seen some, we've heard of a couple that the defense put out that factually are inaccurate in terms of what happened. But people are of the mindset that Elvis, because he's not a bright guy, that his shit is meaningless. Like, how does that work? Like,
Right. How's he just making up something to say, just guessing? It doesn't make any sense. No matter what his IQ is, how's he just happen to guess that there's, what was it, spit or something? I forgot.
Yeah, he thought he was down there. He put the sticks on there, and that Abby was a feisty one, and that now he's got brothers, and I'm in a gang now. I got friends. It's like I completely see this guy who's probably been rejected his entire life because of his lack of intelligence, probably doesn't have a big crew of buddies, who gets sucked into like this thing. And they're like, "Hey man, you gotta leave your mark here," whatever, man. Like in my mind, I can completely envision it, and I can completely seeing him being like excited about it and not really understanding the full gravity of what's going on. And then, yeah, he makes the statement to Murphy when Murphy's dropping him off after his interview at the police station. And that's when he says the thing, "Oh, by the way, if, I spit on one of the girls, but I had a reason for why I did it, I'd be okay, right?" I mean, come on, dude. Like, and it's not just the cop. It's like two of his sisters. It's weird. So 45, it is also curious as to why Vito failed to ask Brad Holder one single question as to the incriminating statements that Amber Holder attributed to Brad Holder that are detailed in Frank's 1. Vito's failure to ask such important questions to Brad Holder during, wait, hold on. I put my little wireless keyboard up there. I just really dimmed the hell out of that. Hold on, everyone. Hold on. Tech stuff. Hold on. Babe, how do I turn up my, I found it. Look at me figuring shit out pretty quick. Okay. Sorry about that. 46, Vito's failure to ask such important questions to Brad Holder during the August 30th, 2023 interview supports the defense contention that law enforcement is acting in bad faith. Mimicked crime scene image found on Brad Holder's social media is lost. All right, now we've heard this before. This is the one that they hunted down in Georgia or something, right? In addition to Holder's 2017 missing phone extraction and missing evidence of Holder's second interview at the Logansport police station, as well as Holder's taped over interview from February 17, 2017, another key piece of evidence is also missing. The mimicked crime scene photo that was on Brad Holder's social media pages. Trooper Purdy viewed this mimicked crime scene image on Brad Holder's social media page sometime in spring of 2017. The image was marked as Exhibit F in Purdy's depot and discussed on pages 79 through 81. 49, the mimicked crime scene image found on Holder's social media page holds an eerie similarity to the actual crime scene. Thank you. 50, in the mimicked crime scene image found on Holder's social media page, the bodies of two women appear to be staged, lying on the ground in the woods with branches laid across their bodies. 51, one of the women in the mimicked crime scene image found on Brad Holder's social media page has her arms staged/positioned in a similar manner as one of the victim's hands were staged, positioned in this case. 52, at that time, the Trooper Purdy observed the mimic crime scene photo on Brad Holder's social media page. The general public did not have the knowledge of the appearance of the crime scene, the positioning of the bodies on the ground in the woods, or that the branches and sticks were arranged on the bodies. 53, in an April 12th, 2017 report from Trooper Ryan Winters, it was learned that the state police also came into possession of said mimic crime scene image through an internet sleuth named Ryan Boucher. I would say they like Bobby Boucher, like the water boy, but it could be Boucher. 54, I'm gonna go with Boucher because I like it more.
All right. By the way, I saw one of the chat comments earlier said that that's the fig guy.
No, that's
Yes.
Gary Baudet is Fig Guy.
Oh, yeah. Sorry, that's what it said.
That's all right. It's all right. And I only know that because he's in the pleadings, not because I care what he talks about. Like, honestly. All right. So Boucher alerted Winters to the disconcerting images on Brad Holder's social media pages and then sent images to Trooper Winters over the interwebs. 55. On April 12th, 2017, Winters then shared with Heuermann his Winters' knowledge of the mimic crime scene images found on Holder's social media pages and the other information. 56. Because of the similarities between the images that Boucher sent Trooper Winters from Brad Holder's social media and the crime scene, Trooper Winters requested that Brad Holder be re-interviewed. 57. Despite that request, state police ignored Trooper Winters and never re-interviewed Brad Holder. Brad Holder was only interviewed in August of 2023 after Heuermann was challenged by the defense to reopen the Brad Holder investigation. 58. To this day, the prosecution has failed to turn over the mimic crime scene image that Purdy found on Holder's social media in 2017. Fortunately, because internet sleuth Boucher had saved the image that he had turned over to Trooper Winters, the defense team was able to drive to Georgia and retrieve the image. I mean, like, this stuff is all in Frank's one. Like, this is all Frank's one stuff. When deposed, Trooper Winters claimed that the state police could not access the images that Boucher found on Holder's social media. That Boucher then turned over to the staties. 61. How could state police lose such an important piece of evidence as an image found on a suspect's social media that mimics the crime scene?
Right. So you're saying that was in Frank's one about this, but I don't know that they've ever. I don't know whether or not, I can't recall whether or not they've ever alleged that this was something that was not turned over or withheld.
Right.
Obviously,
think,
there's no prejudice of it because the the defense has it. I think they're just putting this out there to show important things like this aren't being turned over.
right. Oh, we got a new member. What's up, Shay? All right. Yeah. I like how, like, Andy always puts rhetorical questions in there. How could the state police lose such an important piece of evidence as an image found on a suspect's social media that mimics the crime scene? It's just a question. Just he throws questions in the ponderables. I like to call them ponderables. I mean, it's a ponderable. 62. The defense again would proffer that the mimicked crime scene photo. I can imagine how much, like, Gull just hates reading his shit. It's like, oh, this guy with his questions.
How about she answers one of them?
How about she just have a hearing?
Right.
Hey, look, she was trying to have a hearing.
I mean, that's true.
She's trying to have a bunch of hearings. Got to give her that. I mean, she has some shit lined up.
She waits till after. I wonder if she really knew she was going to be able to get this trial delayed.
Gee, since she, like, had nine motions scheduled for a 3-day period, a full, what is it, 10 days after trial was supposed to start, or not quite, 8 days, 9 days after trial was supposed to start.
Yeah, and she says, I've got to read 40-page in that order. She's like, I have to read this 40-page motion first, but she forgets he incorporated everything from the earlier petition to disqualify that I guess she didn't read. I wonder if he should send an email that says, just a reminder, you've got 40 pages plus, because I incorporated everything in my first one. So that's going to be a lot more than 40 pages.
Yeah, here's my position on Gull at this point. I think that this thing has gotten so personal, just bizarrely personal between everybody involved in this case. Like, in such a, like, and I'm talking about everybody, like between McClelland and, Baldwin and Rosie, and between Gull and Baldwin and Rosie, and between, like, just all of them. It's gotten into this weird personal zone that a case should never get into, like that. So my point being is that it's gotten so ugly and personal between Gull and the defense team that I absolutely think that she reads their shit now. I don't think like back when the Franks 1 came out, like now, like I think she reads it because she's like, oh, what are these motherfuckers saying now? She's like just whipping through the paper, you know, just like, oh, these sons of bitches.
Then she'd know a
I think
little
she's
more about the connections and all the things she seems to not. I mean, there is some merit to the things that they're saying. So if she's reading them and not seeing them, but one thing I did want to say was like that order that you read going into this, that the fact that she's still putting that kind of undertone in there for the Supreme Court to read in black and white, it contributes to this whole like, should she be disqualified? Because why is she putting all this other language in here about, well, unfortunately, I can't do it. And even though this was a date we had all agreed to, and, you know, she's putting it all in black and white. And it does speak to a bias.
Yeah, I obviously, you know, my position with respect to Gull is like she's obviously biased. Like for no other reason than her hating these guys and stating it on the record, thinking that they're incompetent, lazy, shiftless, sloppy, incompetent, grossly negligent. Like everything that she said about them, like, you know, her position on it. We've had this discussion. There's no unringing that bell. You
But
know,
it's
I mean,
still not dawning on her that she should take time when she writes her orders, because the Supreme Court or an appellate court is, unless she removes herself, is about to consider her bias. And she's sitting there still putting little digs into the orders.
but you're jumping to the conclusion that she gives a shit. Like, I do not think she gives a shit at all.
Yeah.
I don't think she cares. I mean, at this point,
Or she doesn't think the higher courts are going to care.
well, look, I think she was emboldened when the high court didn't boot her the first time. You know, I think that really, you know,
Yeah.
she's like, all right,
I'm good. I'm going to
Supreme
keep doing
Court.
this.
Okay, Supreme, you know, it's like that thing. You know, I just don't know if she is reading the stuff. If she there's just so much out there in terms of noise about this case that I'd be stunned if she had the ability to be able to control herself from not looking at it, just to know, for like just out of purient interest, not even going to the point that it's her job, but just like, all right, let me
See what these
see what
jack-offs
everybody's
have to
out there
say.
like yapping about. You know what I mean? Like, just, and like, is her view of the defense so poisoned her mind against them that it does not allow her to get to that place where she's like, well, shit, it looks, you know, this does look suspicious.
Right.
You know, it's like,
And the other lawyers said something similar. I
yeah,
mean, she probably never read their motion because who knows? I mean, I guess we can't really say. All right, we're on page 8. Keep going, Bay.
Kraken, I agree. I still think that she never read that original Franks. I don't there's no going back from it. And like, once she, I mean, and either is the defense, obviously, in like subsequent Franks, they're asking her in there, just in case you forgot or didn't read it, please go back and read it. It's like having to ask a judge to read your pleadings is not normal, kids. That's not a normal thing. Just in case you're wondering if that's like a, you know, sometimes not. Oh, by the way, great job on this border by Dizzy. Dizzy put this together for us. I think it's great. I don't even know if she's in here. She works so hard. I hope she's not. 62, the defense again would proffer that the mimic crime scene photo was not lost. Logic and common sense dictates that such an important piece of evidence would not be lost by the state police. I mean, they lost Richard Allen's statement for 5 years, so maybe. The defense is filing simultaneously herewith its memorandum in support of its second motion to dismiss based upon newly discovered, destroyed, and or missing exculpatory evidence. 64. As detailed in said memorandum, if the defense can show that the missing evidence is exculpatory in nature, then the defense does not need to show that the missing evidence was intentionally destroyed.
It's
If
hard to demonstrate that it's exculpatory if you don't know what's in it.
yeah, I don't have it, but it seems exculpatory.
I mean, they can they can point to all the things that make it seem like Holder's involved, and so there would be something exculpatory, but we know what Judge Hall's gonna I'm sorry, Judge Gall's gonna do with that.
Freudian slip.
Judge
Hopefully
Hall's a very good judge, though.
he's a judge in our county. Did I read 65? If, on the other hand, the defense cannot show that the missing evidence was exculpatory in nature, but can show that the missing evidence is potentially useful evidence, then the motion to dismiss should still be granted if the defense can show that law enforcement intentionally or acted in bad faith regarding the destroyed or missing evidence. Like, babe, like if you didn't know there was a memo here, you know what Allie would be saying? She'd be like, "Where's the law?
Right.
Where
The memo, I glanced it
didn't
over.
they put any law in here?"
I glanced over the memo, and at least the first couple of pages, I was very glad on all the legal analysis I was seeing.
Saw a little law. All right, good. I think that's Auger. I think their new edition. I think she likes to do what you do, which is apply the law. Super helpful in criminal cases.
It's signed by Baldwin and Rossi, so
Yeah, like you know how that goes. You know how that goes. The exculpatory nature of the missing evidence. 66 currently. The list of missing evidence that the prosecution has not turned over to the defense includes the following. A, vid of Brad Holder's first interview from February 17, 2017. B, vid of Logan Holder's interview from February 17th, 2017. C, data from Brad Holder's phone extraction from February 17th, 2017. D, vid from Brad Holder's second interview with law enforcement taken at the Logansport police station sometime in 2017 or 2018. E, audio taken from Brad Holder's second interview with law enforcement taken at the Logansport police station sometime in 2017 or 2018. F, any reports, notes, or documents concerning or referring to Brad Holder's second interview at the Logansport police station, again, sometime in 2017 or 2018. G, the mimicked crime scene photo observed by Trooper Purdy on Brad Holder's social media page. And H, images Ryan Boucher sent to Trooper Winners on April 12th, 2017.
aren't those the same thing, or now are those two different things?
Well, I think it's the same image.
Okay.
I'm assuming it's the same image as like this dude.
It's hard to lose an email.
Really is. It's tough. Like, I mean, they're there. They're out there if you're looking, you know. Definitely.
There's still 11 pages, and they've already set out all the things that are missing. All right.
Yo, 11. All right. Notice that all missing items are related to third-party suspect Brad Holder. Also note, 68, that the prosecution is asking the defense not be allowed to even mention the name Brad Holder at trial. 69, currently the list of evidence that the prosecution failed to turn over to the defense until the defense requested the prosecution to turn it over, or upon the prosecution realization that the defense would be learning about the existence of said evidence, includes a Todd Click letter and accompanying 85-page report. The prosecutor held on to this evidence for over 4 months until he knew the defense would learn of its existence. B, multiple Elvis Fields interviews. C, Rod Abrams interviews. D, multiple Johnny Messer interviews. E, multiple Taylor Hornaday interviews. F, Ned Smith interview. And G, the Libby German phone dump. 70, notice that items A through G in paragraph 69 above are related to third-party suspects in Odinism. 71, also note that the prosecution is asking the defense not be allowed to even mention any of these third-party suspects or Odinism during trial. 72, the evidence that the defense does not have in his possession showcases that on multiple occasions, third-party suspect Brad Holder has changed his answer concerning a very basic question. How many times have you met Abigail Williams? 73, according to the only police report that memorialized Brad Holder's accidentally destroyed first interview, Holder stated that he never met Abby Williams. 74, at the time that he was first approached by law enforcement, February 17th, 2017. Like, so where'd you go, babe? Where you at?
Right
So,
here.
like, you read Andy's stuff, right? And I'm sure that people are like, especially the people that hate them and think that they're clowns and just, can't stand these two lawyers. You read it and it's redundant. It's redundant, not like only in itself in the pleading itself, but it's redundant to other pleadings, right? He says the same shit kind of over and over and over again. And here's the thing, and I don't know this to be a fact, but I think that he's doing it for exactly what the people in the chat were talking about, is that he's assuming that this woman has never read anything.
And but you do have to treat each pleading as though it's a brand new one that sets out everything, unless of course you do like, I'm incorporating, X, Y, or Z, but for the
But I
purposes of
mean, yes, absolutely true. But and he has, like, in all the Franks, he's always incorporated prior Franks, but he's still restating it, I think, because he does not believe that she's ever read anything preceding it.
right.
And I think his hope is that at some point she's going to read something. And he doesn't want it to be the one
Lost
time
on
that
her.
she decides to read it that he didn't put the shit in there. That's
Right.
just a guess. It's just a guess. All right. So at the time that he was first approached by law enforcement, February 17th of 2017, and asked that question, how many times did you meet Abby Williams? Common sense would dictate that the answer would be fresh in Brad Holder's mind and easy to detail because of A, the proximity and time that Brad Holder's son dated Abby Williams. Logan Holder was dating Abby Williams at the time of the murders. And B, the enormity of the situation, i.e. the two girls had been murdered, one of whom dated Brad Holder's son. 75, if Brad Holder is in any way involved in the murders, as the defense believes the evidence strongly supports, then Brad Holder's claim close in time to the murders that he never met Abby Williams is understandable. Denying that he, Brad Holder, had ever met Abby Williams could, in Holder's mind at least, cause the police to take their attention off of Holder. 76, if at his February 17, 2017 interview, Holder was telling the truth that he had never met Abby Williams, then his answer to the police when asked the same question, even 6.5 years later on August 30th, 2023, should easily be the same. I never met her, because a father would definitely remember if he had ever met his son's girlfriend who had been murdered. I agree with that. Like, if it's like a kid that my 11 or 12 or 13-year-old dated for like 3 weeks, I wouldn't remember. If that kid were murdered, I'd remember it.
Right.
I mean,
but you would generally remember the girlfriend of one of your kids or the boyfriend of one of your kids coming over. Like, that usually stands out, especially when they're young.
well, do you remember like Scarlett's first little boyfriend? You probably
Yeah,
don't
when he came
remember.
over to the house.
Do you remember his name?
We're on a stream. I'm not talking about kids' names.
I'm not telling you to give his last name. I'm not trying to dox the kid. I'm just saying, I'm
All
testing
right.
you.
Testing.
You. Well, you failed, because I think that was just, I think you were just trying to put me off by saying, I'm not going to put that kid on blast. I mean, the kid's name could be Jimmy. Like, what does that do? Little Jimmy? Conversely, a father would know if he had never met the murdered girlfriend of his son involved in a high-profile case. However, if at his February 17, 2017 interview, Holder was not telling the truth as to how many times he met Abby Williams, then it may be difficult for Holder to remember what lie he told law enforcement 6.5 years earlier on February 17th of 2017, when he re-interviewed on August 30th of 2023. It's very true. It's hard to keep track of your lies. It's very, very difficult to keep track of your lies. 78, at his August 30th, 2023 interview, Brad Holder's story changed. Now he claimed that, in fact, he had met Abby Williams one time. 79, either Brad Holder intentionally lied to the police in 2017, closer in time to when Logan dated Abby, or Brad Holder had simply forgotten his meeting with Abby Williams, but then somehow remembered that meeting 6.5 years later. Then, at this May 2nd, 2024 deposition, Brad Holder provided yet a third different answer. He'd actually met Abby Williams 2 times. 2 times. 81, furthermore, at his May 2nd, 2023 dep, Holder remembered that one of those meetings occurred at Patty Westfall's house. That's crazy to me, man.
I like, because I'm not.
But how?
I'm a
How
little.
did that happen?
That's what I was going to ask, because I'm a little unclear on all the connections, unless I'm like going to pull it up and look at it again. But
Well, I'll tell you.
is this wasn't the state trying to deny any connection between Holder and Westfall, or no? They're not trying to deny that.
The Holder and Westfall, I think they can't deny. Like, there's plenty out there that those guys were friends, part of this, whatever you want to call it.
Oh, they're the ones that did something out in the woods and then got in a fight?
Right, got in the beef.
Okay.
Patrick Westfall's story, well, like, there's 2 different versions of it.
Something happened out in the woods around where this happened, and then they never talked
like
again.
Amber's version is that it was like something went awry during a ceremony, a ritual ceremony. And Westfall's story is that he found out that Brad was going to normal folk church, and he didn't like that.
Didn't like that at all.
You're dead to me, Brad Holder. You're dead to me. You went to normal folk church. Didn't have.
But yeah,
so there's 2 different theories.
How does this meeting at the house happen?
How does it come about?
It's hard to think that he could have forgotten that and then all of a sudden remembered it.
Well, what I'm trying to get at is, if the one meeting takes place, how does Abby end up at Patrick Westfall's house, but for him being, or him, like Logan and Abby being brought there
right
by Brad, right? I mean,
that's the only thing that makes any sense.
All right. 82, Brad Holder's ever-changing answers to such a simple question provides evidence that the missing items, A through H, detailed in paragraph 66, are exculpatory in nature. 83, when combined with the evidence contained on Brad Holder's social media pages, include images of a rune inked onto Holder's hand that mimics the way that the sticks were formed on Abby's body, as well as the other evidence detailed in Frank's 1, the ever-changing stories of Brad Holder on the simple topic of, quote, how many times did you meet Abby Williams, should all provide insight into why the defense believes that the missing evidence contained obviously exculpatory evidence. How could it not? Ponderable. 84, it would be impossible for the defense to show that the missing evidence contains clearly exculpatory evidence. Therefore, the defense is left with providing circumstantial evidence along with logic, reason, and common sense as to why the many missing items would contain obvious exculpatory evidence.
Okay, 85. So now they're warning everyone. They're like, here is why I'm about to go through all this stuff that the state's going to later say has nothing to do with the missing items. It's because I'm providing you with circumstantial evidence that this was done in bad faith or intentionally.
Which is all they have. This is the conversation we had 15 minutes ago. All they have is circumstantial evidence. Because either the evidence itself has been destroyed, lost, what have you, and the cops aren't going to admit it, and Brad Holder is not going to admit it, and Patrick Westfall is not going to admit it. Like, none of those things are going to happen. So you are left with circumstantial evidence, common sense, and logic. You got to put the pieces together and see, is this a little sus? I mean, to me, it's a little sus. I don't know, but I'm a sucker, like, what do I know? Total sucker. It's a fool born every minute. It's a sucker born every minute of the day. P.T. Barnum, he knew. Um, 85, the defense believes, did I already read this one? That it is shown that the missing
Yeah.
destroyed evidence is exculpatory in nature. The missing / destroyed evidence is exculpatory, but even if the court disagrees, the court should find the missing destroyed evidence as potentially useful and dismiss the charges. 86, as detailed in the accompanying memorandum, if this court finds that the missing or destroyed evidence is not exculpatory, but it does find that it is potentially useful, then the court should dismiss the charges. If it also finds that law enforcement intentionally caused the potentially useful evidence to be destroyed or acted in bad faith regarding the missing evidence. Like this whole argument goes to exactly what like we keep like harping on about. Like they're never going to be able to show that. They're like, but for the judge having an understanding of how much money has been invested in the prosecution of Richard Allen, it's the biggest motivating thing aside from ego. Ego probably falls behind the money that's been dumped into this case against Allen, but ego is a very close second in terms of everybody involved, in terms of this bust, in terms of the chest thumping and the glad handing and the back slapping. You know, it's like they're locked in on this thing. You know what I mean? And it's like there is no backtracking it. And like I said, there is no adding these guys to the mix if they can't make the connection between Allen and these dudes, because it destroys the case against Allen. It just does. Because there's no reasonable explanation how Allen would be bridge guy and just happens upon these dudes who are down there lying in wait. Makes no sense. Hey, what's up? How was practice? Can you get me a Waterloo? I'm like dying of thirst. How was it, Pugs? Thank you. Sorry, little human alert, who I love very much. Okay. Did I read 86 and it's detailed in the accompanying memo? If this court finds, oh yeah, okay. So Frank's 1 through 4 provide many details of why this court should believe that law enforcement intentionally caused the potentially useful evidence detailed herein to be destroyed or acted in bad faith. The defense incorporates the contents. There you go. Another incorporation. The contents of Frank's 1 through 4 in this motion. Provided below are a few of the facts that support the defense contention that law enforcement has acted in bad faith or intentionally lost or destroyed evidence or have failed to turn over said evidence to the defense. A, missing portions of vital video from Jerry Heuermann's 10/26/22 interrogation of Richard Allen. 1, Jerry Heuermann interrogated Richard Allen on October 26 of 2022. Said interrogation was videotaped. 2, however, the first few minutes of the interrogation are inexplicably missing. 3, the missing portions of the video, according to Jerry Heuermann, would have shown Heuermann discussing Richard Allen's Miranda rights and freedom to leave the room, both important concepts that might support the legality or illegality of Heuermann's interrogation. 4, no explanation exists as to why the only portion of the videotaped interrogation that is missed is the crucial beginning of the interrogation. The missing video supports the defense contention that Heuermann knew he had screwed up and therefore edited out the first few minutes of the interrogation to avoid the statement being suppressed.
I'm just going to say again that we already know that the judge hates this kind of, see, they did something, you know, in bad faith here. They did something in bad faith here. So come on, they did something in bad faith now.
Yeah. Oh, hold on. Oh, thank you so much. I love you. Here, give me a hug. I love you.
Love you.
How was practice?
Good.
What do you want to eat?
I don't know.
All right.
Send her down to me, bae.
All right. Sorry, folks. She just got home from practice and she's hungry. I don't blame her. All right. So, did I read through 4? Yeah. Okay. 5, the missing video of Heuermann's October 26 interrogation of Richard Allen is evidence of intentionality of law enforcement involving the concealment or destruction of evidence and or evidence of bad faith. B, Jerry Heuermann lied in his August 10th, 2023 deposition that Brad Holder was never a suspect. In his August 10th, 2023 dep, when asked if Brad Holder was ever a suspect, Heuermann said the following: "Not really, no." 2, however, it is clear from reviewing emails between Doug Carter and the FBI that Brad Holder was a suspect very early on in the case. 3, as stated before, Holder was thought to be a suspect, and his name was known as a suspect even at the highest level of the state police, Superintendent Doug Carter, and even known to Indianapolis top FBI agent Jay Abbott. And then 4, the fact that Heuermann misled the defense by claiming that Holder was not really a suspect is evidence of the intentionality of law enforcement involving the concealment of evidence and or evidence of bad faith. I don't know if it's that, but it's something for certain. Like, it's weird. You know, it's like, but I know it irritates people when we bring up Garcia, but there's just so many parallels between the two cases. It was the same shit when we found this other case of a murder that was very similar to the first set of double homicides, and it was a different person, and like they whitewashed all of our reports that we got to take out the fact that they were initially investigating the crime that had predated the second set of murders, or for our guy, the first set. And they were so similar that when we got all the reports, and I'm talking binders and binders and binders of reports, that there was no mention of this other homicide or of the fact that the other person that they thought was potentially responsible for that crime was all wiped out of these reports. And it was only because we found one FBI memo that mentioned it. And then, of course, Allie started digging and then found articles about it. And then we filed them. It was a whole thing. C, the prosecution failed to turn over the Todd Click exculpatory evidence for 4 months and then only turned it over after that it was obvious the defense would be learning of the existence of the Click letter. 1, as detailed in Frank's 1 and numerous other pleadings, the prosecution chose to not turn over exculpatory evidence from May 1, 23 until September 8 of 23 of a letter from Todd Click and 85 pages detailing the investigation. Contained in Click letter was evidence that 3 law enforcement officers who investigated the case believed that third-party suspect Brad Holder, Patrick Westfall, and Elvis Fields were involved in the murders, and Click's belief that the evidence supporting their involvement in the murders, which was much more compelling than the evidence against Richard Allen. 3, as stated in a previous pleading, it's hard to believe that a much stronger example of exculpatory evidence could exist than documentation that 3 law enforcement officers essentially believe that the wrong man may have been arrested. 4, the fact that the prosecution refused to not immediately turn over the exculpatory Click letter for over 4 months is evidence, circumstantial, but evidence nonetheless, of the intentionality of law enforcement involving the concealment of evidence and or evidence of bad faith. D, the prosecution failed to turn over exculpatory evidence contained in several videotape statements until after the prosecution knew the defense would soon learn of their existence. As detailed earlier in this motion and in Frank's 1, the prosecutor failed to turn over several videotaped interviews that provide exculpatory evidence concerning third-party suspects until after it was clear the defense would soon be learning of the existence of those videotaped interviews. 2, the prosecutor turned over these videotaped interviews nearly 9 months later than required under rule and statute. 3, those videotaped interviews provided exculpatory evidence in terms of blown alibis of third-party suspects, as well as connectivity between third-party suspects and also provable lies by third-party suspects concerning their knowledge of other third-party suspects. 4, the fact that the prosecution failed to turn over exculpatory evidence that supports the involvement of third-party suspects in committing the murders until after the defense would soon learn of their existence is evidence of the intentionality of law enforcement involving the concealment of evidence and or evidence of bad faith.
So if you guys remember in the first hearing for this, she wouldn't let them put in anything that they did not specifically reference in the motion as far as their what they wanted to use to show their bad faith and that they've got a history of, acting in bad faith. So it left them no real choice but to, I don't know, what page are we on here now? Well, do 11, provide 11 pages of it, because I think that's what we ended up saying it was.
Right. Oh no, this is the motion's 20. We're on 15.
Right, but I think it started at like right at page 9. It shifted over to them saying we've got to prove through circumstantial evidence that
Right.
that they did it intentionally or acted in bad faith.
Yeah, for certain.
So now they have to list every single one of them right now. So if people start giving them, shit about that fact, they're forgetting the fact that the judge basically gave them no other option than to put every single instance into the motion. Otherwise, she's not going to let them present evidence of it at the hearing.
Definitely. Thank you for that generosity, Oksana. Look, and always give her.
Thank you.
It's a big one. And welcome to the fam, Afton. Happy to have you. Oh, family hug. All right. So E, the prosecution and law enforcement attempted to conceal the identity of the Purdue professor whose testimony contradicted the sworn statement of Jerry Heuermann. I mean, look, they double, triple, quadruple down on this thing. It's like McClellan fired back and is like, this Baldwin dude is so full of shit. It's like he's completely misstating what words were spoken at this deposition. He's so full of shit. And it's like, it does not deter Baldwin. Like, this is my point. There needs to be the hearing. They have to have the hearing so that we can get all this out on the record. So we can get all the pertinent deposition stuff. That's where Nick McClellan can have his chance to read into the record all of the things that support his proposition that Baldwin is cherry picking the hell out of this testimony by Turco and just, taking it all out of context in order to try to prove a point. We need to have the hearings. And I'm talking about Frank's. I know she's put, like dates on all the other motions. The one thing she just refuses to have Frank's. I mean,
well, again, with the Franks, in theory, if she accepts everything the defense said is true, all right, I'm just gonna, for the purposes of deciding whether there's a hearing, I believe everything the defense just said and still says it wouldn't matter, then that's what she's deciding. But if there's any question and any of it would make a difference, then obviously, yeah, she needs to have a hearing.
Not true there, Michael. You don't know me, dude. Like, and I'm definitely not afraid, but I don't have any proof of it. I hear
scared?
like, yeah, I'm so scared. Don't be scared. I'm not scared. Not scared, dude. But I don't flamethrow unless I have proof. That's kind of my deal. If nice to meet you, if you haven't met me before. This matter has been detailed in Frank's 1, 2, and 3 and in other various pleadings previously filed. 2, at his August 10th, 2023 dep, Jerry Heuermann stated under oath that part of the reason that law enforcement ruled out that persons practicing Odinism or other types or some other type of cult had committed the murders was because a Purdue professor had ruled out such a possibility. Comes from Heuermann's dep. 3, however, after reviewing the Purdue professor's report, prepared on or around March 1, 2017, as well as listening to the Purdue professor September 19, 2023 interview, it was determined that Purdue professor never made such a claim as Jerry Heuermann stated in his dep. 4, furthermore, at his dep, the Purdue professor specifically denied that he had ever made the very statements that Heuermann attributed to Turco. See, this is all a restatement. Like, we've heard all this stuff before, all of it. And again, I could see how this would really irritate some people because he is very repetitive. But again, I'm just gonna hazard a guess that he does this because he firmly believes that Gull does not read any of the pleadings. So he just restates it in the hopes that one of these times she's actually going to read it. It's my best guess. Because he's already incorporated everything, you know, in terms of all the other, the Frank's motions are all incorporated. All this stuff is in there. He doesn't have any faith that she's read any of them. So he just continually restates it because he wants to get it in front of her. He wants her to see it. He wants her to read it. So additionally, I'm on 5 now. Additionally, the prosecution told the defense in September 6, 2023, emailed that the identity of the professor was still unknown and may not ever be able to be found. This was untrue, as Jerry Heuermann had already learned of Jeffrey Turco's name weeks earlier. Additionally, the defense learned that the actual report from March 1, 2017, which also contradicted Heuermann's deposition testimony, was in the possession of law enforcement since that time, but was purportedly rediscovered by law enforcement by law enforcement in August of 2023. Prosecution finally produced said report to the defense on October 4 of 23, and only upon the request of the defense. 7, Heuermann's August 10th, 2023 DEP testimony was false concerning the findings of the Purdue professor, and therefore his testimony is evidence of law enforcement's intentionality in attempting to conceal evidence and or evidence of bad faith. And then 8, the attempt of law enforcement and the professor, or the prosecutor, I'm sorry, to conceal the identity of the Purdue professor is further evidence of intentionality in attempting to conceal and or evidence of bad faith. So you can see here at 8, like the kit gloves have been taken off, all the niceties where they were given old Nick the benefit of the doubt, you know, that I don't think Nick would have done this. Like now he's lumping them in. He's like, he's lumped in with those guys. Yeah, Nick was trying to keep it from us too. I mean, the gloves are off here. I mean, if you didn't know it, if it wasn't exactly clear, I mean, like neither side's holding any punches back here. You know, they're all just shitting all over each other. F. What's going to be really interesting to see when this thing shakes out, when this trial's all said and done, is where the disciplinary committee's coming down. You know, because it's a completely separate thing. Like on all of these people, like on McClelland, on Baldwin. I don't know about Brad. Like, you know, like it's all out there for public consumption. You know, like they pick on lawyers, and especially when it's out in the public. I mean, we saw it in Garcia. I mean, shit, we were dealing with the ARDC for years after Garcia for things that like they were like grilling us and giving us shit because we did a poll. It was great. It was great. Like we had to do a poll. How do we know if the people like? But it's like, you know, like I'm curious to see how this is going to shake out with that, and if.
Well, when you say a poll, you mean a change of venue motion and corresponding change of venue poll.
What do you mean?
Well, because people don't know what you mean when you say we did a poll. So I'm just saying it was.
Yeah, it was a poll.
If anyone's following the, is it Coffinger? No,
definitely not Coffinger. Koberger.
Right, Koberger. Was that who they just had the poll, or was that somebody else? Another one of the trials.
Yeah, the survey. Yeah, the poll
Yeah.
survey. Yeah, that was Koberger. It was him. Are you going to finish your thought? You said
that was it. I was just saying that's the same type of poll.
Yeah, same kind of concept, right? All right. Prosecution failed to turn over one of the key pieces of evidence for nearly 9 months, and then only after the defense kept requesting prosecution for the same. One key piece of evidence in this case is the phone data extracted from victim Liberty German's phone. I would say that that's key. That's critical key. Evidence.
That is critical.
That is critical evidence. 2, that the prosecution and law enforcement had possessed that evidence for 5 years prior to Richard Allen's arrest, and therefore should have been able to provide that evidence immediately to the defense. Agreed. Hard agree. Had that for years. It's probably the first thing they did. However, the defense did not receive that evidence until September 8th of 2023, almost 9 months later than required under criminal rule. Forget about the criminal rule. Like, that's just shady shit. Not turning over the victim's phone extractions forever. It's shady. I don't care what anybody, like, it's like, that is like, that piece of evidence in particular disturbs me more than anything.
Yeah.
It's the victim's phone extraction, for God's sakes. You're not turning it over to the defense. Like, how can you not think something potentially nefarious is going on when they're playing hide the ball on the defense with that type of evidence? It's weird. 4, after the defense had a chance to review said data from the phone, it was determined that exculpatory evidence existed in the phone that did not support law enforcement's timeline and supports that third-party suspects were involved in the murders. And then 5, the failure of law enforcement to turn over Libby's phone for nearly 9 months, thereby concealing exculpatory evidence the defense could have been exploring from the beginning of the representation, is further evidence of the intentionality in attempting to conceal evidence and or evidence of bad faith.
And they could have been very specific there if they're just trying to play it, do it for the public and to get the stuff out to the media. They just said very blankly that it contradicts the timeline that they put forth.
Does, for certain. All right, law enforcement concealed the Blocker report or Blocker until April 26, 2024. On April 26th of 2024, the state of Indiana turned over a report from Steve Mullen concerning the findings of Sergeant Mitch Blocker of the Indiana State Police. 2, contained in the body of that report was exculpatory information concerning ping. Andy, you don't know what pings are. Quit talking about pings.
Bob's kidding. He does not know that Andy does not know. That's just what this defense,
That's what
the
McClellan says.
Right.
Andy don't know shit about pings, bro. You don't understand pings, homie.
Yeah,
concerning ping information that supports that on February 13th, 2017, the victims were not located at the same scene as they were found on February 14th, 2017.
Or at least
3, well, but Andy doesn't understand pings. You don't understand pings, and McLean says pings don't matter.
Pings don't matter.
You can get there. Sometimes they work, sometimes they don't. Here they didn't work. It's a shame. 3, the failure of law enforcement in turning over this report for well over a year beyond when the prosecution was required, and only after the defense had a certified letter and filed a motion to compel and for sanctions demanding the prosecutor turn over for evidence, is further evidence of intentionality and bad faith. H, Toe Blazenby contradicted the sworn statement of both Jerry Heuermann and Tony Liggett concerning the number of people involved in the murders. 1, this matter is detailed in Frank's 1. 2, but just in case you've never read it and never will, I'm going to tell you anyway. 2, that both Liggett and Heuermann testified under oath that only one person, Richard Allen, was involved in the murder of the victims. 3, this proclamation under oath by Liggett and Heuermann would negate the defense's contention that evidence supports that multiple people involved in Odinism were involved in the murders. 4, however, when Tobe was deposed, he, Lazenby, stated under oath that Tony Liggett actually believed that multiple people were involved in the murders. 5, this conflicting sworn testimony of law enforcement is further evidence of intentionality on the part of law enforcement to conceal their actual beliefs concerning the number of people involved in the murders of the victims in order to direct the defense away from the theories that Odinists were involved in the murders, and additionally is evidence of bad faith. No recordings of Richard Allen interview with Dan Doolin exists. This is an irritating one too. In 2017, Dan Doolin had stated that he knew that he had audio recorded interviews when conducting the interviews of tips and leads. Doolin claims that he now believes that he never audio recorded his interview of Richard Allen. Quote, I think I must not have that audio recorded because all the other ones that I had are in a file on my computer, and I listened to each of them just in case they were mislabeled. Every audio recording I have, and none of them was Mr. Allen. Dan Doolin. 3, this interview is as crucial as what dueling claims Allen told him helped establish a timeline used to secure a search warrant and arrest Allen. 4, it's very true. Like Allison and I were just talking about that last night. This timeline, like these 2 competing times, you know, from 12 to 1:30 and then from 1:30 to 3, like the defense believes that the Richard Allen was tape recorded and the missing tape supports intentionality on the part of law enforcement and or evidence of bad faith. And then missing mimic crime scene image. This was detailed earlier in this motion and in Frank's one. The fact that this is incredibly exculpatory piece of evidence cannot be accessed and therefore is still missing, causing them to travel to Georgia to obtain said images, evidence of the intentionality of the part of law enforcement to conceal exculpatory evidence and or evidence of bad faith. 90, Brad Holder is a key third-party suspect, yet Jerry Heuermann denied that fact, and then law enforcement failed to turn over multiple pieces of evidence to support Holder's involvement along with other third-party suspects identified in Frank's one. Furthermore, law enforcement have claimed that Brad Holder's initial interview was taped over. Furthermore, law enforcement claim apparently that they never extracted data from Holder's phone when they extracted data from at least 101 other phones from people who weren't even suspects like Holder. Furthermore, law enforcement claim apparently that they never extracted data from Holder's phone when they extracted data from Logan Holder's phone, which was turned over to the police at the exact same time that Holder turned his phone over. Furthermore, law enforcement has turned over 0 evidence of Brad Holder's second interview conducted at Logansport police station, and the defense only learned of said interview through a DAP of Brad Holder conducted on May 2nd of 24. Furthermore, law enforcement claims that they cannot access the mimic crime scene photo that was on Brad Holder's social media page. 96, all of the issues of missing evidence surround one person, Brad Holder, and Odinism, which the prosecution is also attempting to block the defense from even mentioning at trial. 97. Richard Allen cannot have a fair trial when exculpatory evidence that would support the involvement of third-party suspects is missing. And 98. Only so many coincidences can explain away why so much evidence concerning Brad Holder and Odinism is still missing, and why the prosecution failed to turn over much of the evidence that the defense does in fact possess concerning third-party suspects for 9 months or 9 months or more, and only after the prosecution knew that the suspect would be learning of the existence of that third-party suspect evidence. 99, the bad faith of law enforcement and prosecution has been proven through these numerous examples of missing evidence and evidence that the prosecution failed to turn over to the defense in a timely manner. 100, cool 100. Why couldn't he just add, like, ended on 100, solid, a C note? Had to go 101, just had to do it. 100, because the missing evidence is exculpatory in nature, the charges against Richard Allen should be dismissed, sir. Even if the court finds that the missing evidence is not exculpatory, it is clearly potentially useful evidence, and the numerous examples of bad faith contained in this motion require the charges against Richard Allen be dismissed. Did you notice they quit calling him Rick in their pleadings? Did you notice that?
Yep. I mean, I didn't know if they did it in all of them or it was
They did it in a lot of them. They did it in a lot of them. All right. Wherefore, pursuant to the law detailed in his memorandum in support, like if they wouldn't have filed this memorandum along with this, my wife over here, this little pretty smart woman, would have been fucking on fire.
Well, it makes sense why they did it like this. Have somebody focus on just the law. We'll focus on just the facts, although we'll see if they apply the facts to the law in the memorandum, which is obviously very useful.
Aw, $20 haul. Thank you. No, Jen, you're amazing. Thank you for generosity and being an amazing mod.
I keep going back and forth while I'm making dinner, but I'm listening to you on
all right, well, this is the stuff that you want to know.
I know.
This is your world here. This is the law. This is the law. I really want to have an on right now, but they make me hiccup.
What makes you hiccup?
The little ons, my little.
Oh, sorry.
Like if I put it in, it makes me hiccup. People probably like, why is Bob hiccuping? And because sometimes like the fumes get to me or something.
Well, why don't you thank some people?
I've already thanked them all. I've been doing it
Oh.
contemporaneously.
All right. Well, what about some questions from our members?
I don't know that we have any. Nobody's mods haven't thrown any up, so I don't know. And I can't read the chat when
I know
when
you
I'm
can't.
reading,
I can't.
so I have no idea, no clue. And I didn't put the brick on it. I meant to put the brick on it. I like to slow the chat down considerably, like cause like a 15-second delay. And I also forgot to make it that only people that are members or subscribe to the channel.
Oh, Bob,
I'm
come
going in and
on.
I'm changing it right now.
Come on.
I agree. That's whack. I think if you're going to be in the chat, you got to be a member. That's
Yeah.
that's the deal.
Well,
Or
you
you got
got
to
to
be
subscribe,
subbed.
you mean.
You
You
got
got
to
to
be
subscribe.
Yeah,
Right.
exactly. Gotta
For
be
free, no cost.
Right.
No cost.
All right. So I'm gonna work on this little on for a second while I'm changing this. I'm gonna change it right now. Can't be stopped. Can't stop me.
I mean, I'm pretty
Like
sure
in
that
the future mods, like my mods that are in here, like if I haven't set those, especially on a
yeah,
Delphi,
it's my rule. My rule. He's got to follow it. Plus, it keeps people from coming in and just talking smack, just because.
No, I mean they can unsub, which they do.
Right.
I'm gonna slow it down 10 seconds right now. Boop. Slowed
right.
it down.
I'm gonna go take care of finish up some more dinner stuff.
5 minutes. All right. Cool. All right. Fixed it all. There you go. And it helps me really because at some point I do like to read through the comments, and you guys are so fast and furious. It's like a 15,000 page book. Like there's no way I can get through anything. So mods, if you see anything, if you guys see anything interesting question wise, throw it up. Oh, let's see. Roswin need to get some direct evidence to give the circumstantial case have legs. I agree. What do you think they can find, Mike? I don't know. It's tough. All right, let's start digging into the law. So it's one thing to write a bunch of words and submit it as a motion to a judge. And it's another to supply some actual case law that supports your position and provides cases where in other cases that similarly situated defendants cases have been dismissed where similar things have occurred. That's why you cite precedent. So you cite precedent to give the judge the law in terms of what burden they must meet or what tests they must apply. And then you give the judge examples of other cases that exist in Indiana, hopefully, of situations that are similar to the situation here, wherein the judge found that it was an appropriate remedy to dismiss the charges. So that's what we hope to see in a memo of law, because when they file a motion with no case law in it, it's them's just words. That's it. Them's just words. All right. So let's go. All right. All right. Going to enable the scrolling because it's the best. All right. The memo of law in support of. So at issue is the purposeful or negligent failure to preserve and or destruction of material and exculpatory evidence critical to the defense of Mr. Allen. It also involves the attempted concealment of the identity of a key witness. Talking about Turco. Typo. And the other exculpatory evidence. Well, they put a T at the end of Turco's name. There's no T. Such as the Todd Click letter and evidence referred to by Click in his letter. This would include new examples of missing evidence detailed in the motion filed simultaneously herewith. Indiana Code 3431 or 3534 1-4A states that this court may, upon motion of the defendant, dismiss an information upon certain grounds. In this case, the defendant requests that the court to dismiss this information pursuant to Indiana Code 3534 1-4A11. which states that a motion to dismiss an information may be granted for, quote, any other ground that is a basis for dismissal as a matter of law. Quote, such grounds would include a violation of the defendant's constitutional right to due process. Additionally, trial courts have an inherent authority to dismiss criminal charges where the prosecution of such charges would violate a defendant's constitutional rights. Section 3534.14 is merely legislative recognition of this authority. Matlock v. State. See also State v. Davis. Quote, such grounds would include a violation of the defendant's constitutional right to due process. A motion to dismiss based upon a ground specified in said statute may be or renewed at any time before or during a trial. And then see said statute. Oh, that's actually 3534.14b. Therefore, this matter is properly and timely raised. So first they're dealing with the issue of whether or not this is ripe or it's timely. So that's why they put that law in there. So the judge can't say, well, should have done this, before trial, or they're just giving her the law so she knows that this is a timely request. Indiana Supreme Court has held that a serious breach of duty occurs when the prosecution willfully or intentionally, when unjustified by public policy, obstructs the access of the defense to material evidence in a possession. Turnpaw v. State. It is likewise a serious breach when, through the lack of vigilance, the negligent destruction or withholding of material evidence by law enforcement officers or the prosecutors occurs. In such instances, grounds for reversal may exist. Id. So that's, again, Turnpaw. The Indiana Supreme Court has also held that negligent or intentional destruction of evidence by the police can provide grounds for reversal or dismissal on due process and due course of law grounds. Berkla v. State, Hale v. State, Rowan v. State, Braswell v. State. Quote, prior to any request. So these are all plucked directly from cases. So the way that it works is they'll pluck language directly from a case. You'll see it in quotations. And then afterwards, they'll cite the case where they plucked that language from. So prior to any request for discovery by the defendant, the negligent destruction or withholding of material evidence by the police or the prosecution may present grounds for reversal. Berkla, citing Hale. Indiana Supreme Court has held further that when the prosecution determines evidence to be non-material and further decides not to advise defense counsel of such evidence prior to its destruction, a heavy burden rests upon the prosecution to demonstrate that the destruction of such evidence did not prejudice the defendant. It at 649. Quote, the appropriate test to apply when deciding whether a defendant's due process rights have been violated by the state's failure to preserve evidence depends on whether the evidence in question was, quote, potentially useful evidence or, quote, material exculpatory evidence, Blanchard v. State. The burden is on the state to demonstrate that this evidence was not material and its destruction did not prejudice the defendant, Cox v. State. So there's a little burden shift there. Potentially useful evidence is defined as, quote, evidentiary material of which no more can be said than it could have been subjected to tests, the results of which may have exonerated the defendant. Id. So that's id as to Cox v. State. The state's failure to preserve potential evidence, potentially useful evidence, constitutes a due process violation when the defendant can show bad faith. At 27, the Seventh Circuit has held that bad faith may be inferred when a party disposes of evidence in violation of its own policies. And then it cites Park v. City of Chicago and Lattimore. Those are Fed cases. Quote, violation of a record retention regulation creates a presumption that the missing records contained evidence adverse to the violator. The bad faith presumption arises when the failure to retain records or other evidence actually violates the terms of applicable policy. Id. However, the Indiana Court of Appeals has noted that, quote, in some instances, the destruction or failure to preserve evidence may be so prejudicial to the defendant as to warrant reversal, even in the absence of bad faith by officers. Stoker v. State. Material exculpatory evidence, on the other hand, is defined as evidence that possesses an exculpatory value that was apparent before the evidence was destroyed and is of such nature that the defendant would be unable to obtain comparable evidence by other reasonably available means, and that's Blanchard at 802. The state's good or bad faith in failing to preserve material exculpatory evidence is irrelevant. See, now why it's important for them to cite law is that it puts the onus on Nick McClelland to cite opposing law. Like Nick McClelland just can't come back and say, "Oh, well, they're all full of shit. They're lying. They're citing case law. They've provided 20 pages plus four Franks motions of their circumstantial evidence that these things have occurred." And now they're backing it up with the law, which is going to require both McClelland and Gull to deny it, to cite some law of their own. The Indiana Supreme Court has held that the defendant must establish materiality as a condition preceding to claiming a denial of due process where evidence is negligently lost or withheld by the government, except where the materiality is self-evident or a showing of materiality is prevented by the destruction of the evidence. Levy State.
So I was just going to mention, like, the case that they cited before that, was talking about a presumption when there's evidence that could be tested. I mean, that more they're talking about, like, you lose a blood evidence, DNA evidence, like something that can be forensically, scientifically tested. So it thus far, he hasn't applied like specific facts to the specific case here.
Right.
Although technically, a phone, although the extraction itself can't be tested, if they have access to the device itself, that can be tested.
For sure. And like what Allie's saying, like if you were to read one of her motions, she'll cite the law, and then what she'll do, and she'll typically cite the law. She'll give some like a brief summary of the fact patterns of that case, and then she'll say, here, applying the law to this case to demonstrate to the judge why this particular piece of a case or a holding or a rule or a test applies to the case at the bar.
And I'm sure they'll get to it here. I mean, it's obviously not anything special that I'm doing. That's what every lawyer who's legal writing is doing.
How it's supposed to be done.
Right.
Okay. An item is material if it appears that it might benefit the preparation of the defendant's case, or it might reasonably affect the outcome of the trial. See Williams v. State. In this matter, there you go. Given the nature of the evidence that law enforcement either failed to preserve or actually destroyed, the materiality was and is self-evident. Furthermore, as in Lee, the failure to preserve or the destruction prevents the defense from establishing the exculpatory nature of the evidence and its materiality. It's that therein lies the rub, right? I mean, it's destroyed. So what do we got? As such, Allen is not required to demonstrate the materiality of the evidence. To be sure, the unavailable evidence had, quote, exculpatory value, which was apparent at the time. It should have been preserved and prior to its destruction. Additionally, Allen is unable to obtain comparable evidence by other reasonably available means. Now, that's a very important part of this. Like, Allie, I forget which one of the previous motions, but that was, I think your end analysis was that as to a couple
things. It was the first motion to dismiss for the destruction of is it Holder again? The initial Holder interview where they had the police reports.
Right. Yes.
Here, for that second interview, they don't even have any police reports at this point. And, for the iPhone, for the cell phone extraction, what I did want to ask, I saw Michael was here, and I don't know if he does mostly appellate law or if he does, or he's a professor, right? I don't know if he did criminal, like had a criminal practice or has a criminal practice, because we've talked about this before. Like in most of the cases we have here in Illinois, there's going to be like an evidence log that the police keep. And even if you don't you know, like you can specifically ask for it. That's going to show every piece of evidence, who put it in, what time it went in, like just something that the police are keeping to keep track of everything, to know whether or not a phone went into evidence.
Yeah, no, well, so yeah, he does. Well, he was doing habeas work through IU with his students, and for some godforsaken reason, IU has terminated his program, which was incredibly successful. It's a real shame. He's pretty bummed about it.
Well, I mean, that was one of the most valuable, you know, kind of like a hands-on
Well,
criminal law.
it was a clinic, like
Right, that's what I'm
literally,
saying.
like
Our clinic was one of the most valuable classes that we had in law school
like I would argue it was
programs.
the most valuable class in terms of practical application of what we're learning in law school and how to actually practice law. It was by far the most important class we took. Everything else was, you know, esoteric
Nothing.
black letter law. This is how you pass the bar. This is what you need to know. And then the only practical experience you get is like a clinic. And like,
Oh, there
not
he is
only
right
was,
there.
I
Get the
know
evidence lists. So
what I was saying, get the evidence is for 27th. Yeah, no doubt.
so then apparently they should be able to get that from the police. That's what I'm just like, where are the evidence lists?
Right.
And whatever it was, yeah.
All right. So then they cite Blanchard and then Glatzbach v. Froman. And then we've got spoliation of evidence is the intentional destruction, mutilation, alteration, or concealment of evidence if spoliation by a party to a lawsuit is proved. Rules of evidence permit the jury to infer that the missing evidence was unfavorable to that party. Even if this court requires a showing of bad faith, it is apparent. Bad faith is defined as being not simply bad judgment or negligence, but rather implies the conscious doing of wrong because of dishonest purpose or moral obliquity. Obliquity is defined as deviation from moral rectitude or sound thinking. See Webster's. The United States Supreme Court has recognized that the police have a constitutional duty to preserve such evidence. In Trombetta, the Supreme Court observed that, quote, whatever duty the Constitution imposes on the state to preserve evidence, that duty must be limited to evidence that might be expected to play a significant role in the suspect's defense. California v. Trombetta, a 1984 case, Supreme Court style. The court recognized that same duty in Arizona v. Youngblood, 1988 case, confirming that the Constitution imposes at least a limited obligation on the police to preserve evidence that could form the basis for exonerating the defendant. It is beyond debatable that the evidence at issue here would play a significant role in Mr. Allen's defense and would form a basis for exonerating him. Additionally, quote, this suppression by the prosecution of evidence favorable to the accused upon request violates due process where the evidence is material either to guilt or to punishment, irrespective of the good faith of the prosecution. Bold, for emphasis, Brady v. Maryland. To prevail on a Brady claim, the defendant must establish, one, that the prosecution suppressed evidence, two, that evidence was favorable to the defense, and that three, that the evidence was material to an issue at trial, Mimicked v. State. The Indiana Constitution is clear that the federal Constitution is not the sole guarantor of the right to due process and other rights. Chief Justice Shepard made this abundantly clear in his law review article, Second Wind for the Indiana Bill of Rights from 1989, when he stated in conclusion that civil liberties protected only by a U.S. Supreme Court are only as secure as the Warren Court or the Rehnquist Court wishes to make them. Such a great point.
Right.
Such a great, like, I never see judges say that. And it's such a great,
Said every woman in the world today.
said every woman in the world today, right? It's such a great point. The protection of Americans against tyranny requires that state Supreme Courts and state constitutions be strong centers of authority on the rights of the people. I am determined that the Indiana Constitution and the Indiana Supreme Court be strong protectors of those rights. Now, what that means, like, I'm just going to nutshell it. So the federal Constitution is a floor, meaning that a state cannot provide less rights to its citizens than the federal Constitution provides to us all. A state constitution can provide more, however, than the federal Constitution provides. So there's no ceiling on what a state can provide in terms of their rights to their citizens. Do you guys understand that difference between the federal Constitution and the state? It's an important distinction. The Chief Justice also stated that Indiana was an early and noteworthy participant in using its Bill of Rights to defend personal liberty. And after citing to numerous early decisions, noted that these were but a few in a fine line of cases in which the Indiana Supreme Court held that the Indiana Bill of Rights afforded Hoosiers rights which the federal Constitution did not, id at 576. Chief Justice Shepard also noted, or also made note of the fact that many of the provisions of the Indiana Bill of Rights have no counterpart in the U.S. Constitution, and observed that Article 1, Section 12 was one of those provisions, id at 580. This provision relating to due process is at issue in the instant case. The Due Process Clause of the United States Constitution is found in Section 1 of the 14th Amendment to the Constitution. That section states in relevant part that, quote, no state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States, nor shall any state deprive any person of life, liberty, or property without due process of the law, emphasis added.
Did he quote the state constitution, or he just quoted the...
That was the U.S. Constitution right there.
I know, but he's under the Indiana Constitution. So far, he quoted an article written by one of the justices, but not the actual. Oh, maybe he's going to do it next. Sorry.
Patience, young Jedi, patience.
Okay.
The right to due process conferred under the Constitution of the state of Indiana is found in Article 1, Section 12, and contains significant language not found in the Constitution of the United States. Ask, and ye shall receive.
It was just like I scrolled up to be like, wait, did he give me the language from the state one yet? But I see what he's doing here. Okay.
And when you say he,
they,
I want to know if this is auger. Like I don't know, but I haven't seen a hearty memo like this with this much case law in it.
Well, I mean, I'm not going to knock it. But...
I'm just saying, I've read a lot of Andy's shit, and I haven't seen a hearty memo with this much case law in it. Have you? You've been on with me. It's not a slight on Andy. I mean, some people are very powerful legal writers who like to cite a lot of case law, like you. All right. So the provision states all courts shall be open, and every person for injury done to him in his person, property, or reputation shall have remedy by due course of law. Justice shall be, italicized, administered freely and without purchase, completely, and without denial, speedily, and without delay, emphasis added. While the defense is unaware of any Indiana case any Indiana case law specifically interpreting the emphasized portion of this constitutional provision, the provision itself is traced back to the Magna Carta and State Ex Rel Board of County Commissioners versus Larimore. The Larimore court also acknowledged that although the provision was derived from the Magna Carta, or is it Charta?
Carta.
Yeah, it's definitely Carta, but that reads like Charta.
Yes.
That it may be a broader guarantee of free, unpurchased, and impartial justice in Indiana, 485. Three more contemporary decisions dealing with the issue of the destruction of evidence are of particular import. First, it is clear from Chief Justice Shepard's concurrence in the House of State, the issue of whether a lack of good faith on the part of the state was required for a defendant to obtain a remedy for the destruction of potentially exculpatory evidence under the Indiana Constitution had not been decided adversely to the defendant, even after Youngblood. The House decision actually dealt with the discovery of potentially exculpatory evidence and the need for materiality of that evidence. Both Chief Justice Shepard and Justice DeBruler, however, discussed the related issue of the destruction or loss of such evidence. In his concurrence and dissent, Justice DeBruler stated that while I agree with the result reached by the majority opinion on this discovery issue, I point out that when the accused shows the material evidence was in the hands of the prosecution and lost, the question of whether the accused must then go ahead and show prejudice is open in Indiana. In my judgment, when the item is not available for scrutiny by the trial court, but is known to have been material, the risk of loss should be borne by the prosecution, not the defendant. The police and prosecutors are after all highly trained specialists in the gathering and retention of evidence and should be expected to carefully retain all material evidence in usable form. Chief Justice Shepard, in his concurrence, stated the quote, I agree with Justice DeBruler that this case does not decide what standard Indiana should use for cases in which the prosecution has disposed of arguably material evidence which might exculpate a defendant. The instant case certainly appears to be the type envisioned by these comments. 2 Indiana decisions have been found in which the issues of due process and the destruction of evidence was raised under both the federal and Indiana constitutions, Hale v. State and Douglas v. State. Although both of these decisions were determined adversely to the defendants based on the facts of the cases, both also stated that negligent or intentional destruction of material evidence by the police or the prosecution may present grounds for a reversal. Hale. And then in each case, the defense alleged a violation of due process under both the federal and state constitutions. While both decisions were rendered prior to the U.S. Supreme Court decision in Youngblood, Supra, the decision in the House rendered after the Youngblood decision makes it clear that the principle announced in Hale and Douglas may still be valid under Indiana Constitution. Additionally, Lee Supra was decided after Youngblood. If the language in Article 1, Section 12 of the Indiana Constitution, quote, justice shall be administered freely and without purchase, completely and without denial, speedily and without delay, end quote, is to have any meaning at all, it certainly seems to support a more stringent enforcement of due process rights than required under the federal Constitution. Given the facts of the instant case, the penalty involved, and the long history of concern about the preservation of evidence in Indiana case law, as well as the evidence of attempts of law enforcement and the state of Indiana attempting to conceal other material and exculpatory evidence, Mr. Allen should not be deprived of a remedy for the egregious loss of evidence occasioned by the actions of law enforcement and or the prosecution in his case, especially in light of the case with which the evidence could have been preserved. Well written. That's a well-written paragraph right there. Conclusion, short and sweet. The only remedy that serves the interests of justice and guarantees Mr. Allen's constitutional rights is dismissal. Respectfully submitted, Andrew Baldwin, Brad Rosie. All right, so there you go. There it is.
I still feel like they should have technically asked for some alternative remedies there. You know, and I mean, I guess I can see they don't want to. They want to just stick with, I want to ask for dismissal. I think I would have said, but in the alternative, let's do X, Y, and Z, including A, make the state go and test the damn phone. B, have them produce their, you know, the evidence list. C, allow the defense to to request that the jury or tell the jury, instruct the jury that they can draw a negative inference from the fact that the evidence was missing. You know, a bunch of others. I haven't given it much thought, except I just don't think only raising the dismissal and not other issues. I mean, I think I would have been called this something about like, you know, motion to dismiss and other relief, you know,
Right.
and then I would have made some, you know, additional requests.
Yeah, no, and to Scarlett's, Yeah, 0. They're like, look, she's never dismissing this case. They could write 1,000,000 dismissal motions. They can have all kinds of egregious violations, apparent egregious violations by the prosecutor or law enforcement. She's not dismissing this case. It's never happening. What they've done is they've again made a record. Okay, this is all on the record for the appellate court in the event that Allen's convicted. They have to do this. They have to. This is how lawyers talk to judges, and this is how they preserve a record of issues in their case. So, you know, they file the things that they need to file. I don't want anybody thinking that this thing's going to get granted, because I'm gonna go on a limb, and I'm gonna go with the full 0% chance that this is going to get granted. There's no shot.
No.
But you know, again,
That's why I'm saying I think they should have asked for some other relief.
remedy. Yeah.
Yeah.
Yeah, I agree. Oh, Renee, incredibly generous here with another $50 holla. Thank you so much. Love you guys so much, Allie and Bob. I'm over an hour behind, but because
sorry. I'm sorry. I was looking for anything Michael said.
Wow.
And then...
But catching up because kiddo snuggles and bedtime, which always should take precedent over this. Certainly does in our house. Y'all are inspiring, and anyone who doesn't see the value in the constitutional rights we all have, ugh, no words. Thank you, Renee, for that incredible generosity and that wonderful sentiment, which Allie and I fully agree with. So throw up, what did Michael have to say for himself?
I don't remember now. I was just looking for anything that
he said there are some adverse inference instructions to be asked for, but that request comes later. Yeah.
I don't know. Well, couldn't he have asked to you know, get those the evidence lists? And what about asking that they test if they're saying they've never ran an extraction on that phone, that they actually run the extraction?
Yeah. So grounds for reversal would have been again, this is Michael, and if you guys don't know who Michael Osbrick is, brilliant guy, attorney, professor, adjunct professor over at IU. And
his comment is because they were citing cases talking about they have found this to be grounds for reversal, which is clearly not the equivalent to seeking to, dismiss. But, I think they were having a hard time finding those kind of cases.
Right.
And I don't know if Michael's saying,
they said it. They said it flat out that they were having a tough time finding cases, I mean, that happens. One of the functions of lawyers is to make law and to change bad law. Those are like, people forget about that concept, but trust me, in this country, we've had many a bad law that have needed to be changed and have been over the course of years.
I would have requested the evidence list prior to hearing. I would have said at least something like, wherefore that this court order the state to tender to the defense the evidence log, the police evidence log for the state, that for the entire freaking thing from day one to day end, to be perfectly honest. But so that they can determine whether or not that phone was ever brought in.
So Big Mateo, with the possible amount of corruption in the county sheriff's office, do you think RA is safer than another facility? I think he's safe. I think he would be safer in Cass or Tippecanoe than a county jail. I just do. It's just that they're much smaller facilities. It's like, it's harder to get away with shit in smaller facilities.
But Michael, I'm assuming that they
don't have to ask the court for that. Just an everyday request for
right. But I'm assuming they've asked for it and don't have it. But maybe I'm wrong. Maybe they do have it. But
well, they're definitely not going to make new law here. But who knows? Shouldn't say definitely, but I agree with you. I think it's unlikely.
They almost never make new law, except when they want to take your rights away. Then they're really easy to make new law.
Right. In order to make new law in a case like this, Allen's got to be convicted. It's got to go up in appeal. Remember, if he's if he's found not guilty, there's no appeals. The state cannot appeal cases. So, at least after a verdict. So let's see. All right. I think that is it, Bay. So, as we stated, I have been saved the trip. I don't have to drive to Delphi tonight, which I'm very happy about. Truly. I mean, I'm not going to lie, I was pretty excited about hearing some of these motions, but the timing of it, I was not excited about. So I'm thrilled. And plus, I'm very excited about the Karen Reed trial, which is going tomorrow, because Jen McCabe is going to get cross-examined by Alan Jackson. And I think that's going to be a banger. So if you follow us, and if you are not following the Karen Reed case and you follow Delphi, I would highly recommend you take a peek at that case. It is equally insane in a lot of different ways. It really is. And we're at this point 2+ weeks into the state's case in chief, or the Commonwealth, as it were. So it's moving along, but it's a fascinating case. And I have it streaming on our channel tomorrow, or on our channel. If you're not subbed here, we'd love if you subbed. We'd love if you like and share. Helps us grow the channel. And we're growing. We're up at, we broke 17.5 today, babe. 20's on the horizon.
Nice.
Yeah.
I just decided to check everybody. So I see 600. Oh, no, wait. I'm looking at the wrong thing. Sorry. Wait, how do I see how many likes there are? Oh, boy.
Yeah, and for those
355 likes and 1,179 people. So please, 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 on your way out, just minimize your comments and click the thumbs up.
Yep, it really helps us. Really, really helps us. All right, to all my mods who worked overtime once again today, and always work overtime, we adore you. We are so thankful for you. Every single day, every live, every day we're not doing lives. You guys are behind the scenes doing so much work that really, we can't do this without you guys. You're an army that are absolutely vital to everything that we do. So thank you 1,000 times over. And to you, all you beautiful people out there that continually hang with us, we appreciate you more than you'll ever know. Because without y'all, I'd just be an old man
talking about a lot of cases.
Damn Skippy. Talk with you later.